Mr. Cross, are you present?
I am present.
Okay, if you would come stand in front of me here.
Do you mind if I use counsel table?
You can. Mr. Cross, how do you wish to plead on these citations? And you can plead different on each one. You don't have to plead the same way.
Recording.
Okay. I actually have some paperwork.
Okay. Before I get to that, I need you to enter a plea.
Stop recording.
Are you pleading guilty, not guilty, or no contest?
Before we get to the plea,
Goodbye.
I wish to make sure that we're moving under due process of law.
We are. Okay.
So we're moving under due process of law.
This is due process. You're having your time in court. Okay? So, do you wish to plead guilty, not guilty, or no contest?
I don't have any intent. I don't mean to be contemptuous in any type of manner. But moving under due process of law, I wish to have the facts of the claims placed upon the record so that I know and understand how I plead.
Okay. I'm going to enter a plea of not guilty on your behalf so we can move on to a trial. And at that trial, the facts will be presented to the court from Officer Douglas is here on behalf of the county. So I will ask him to present those facts, and you can hear those facts. And at any time, should you wish to change your plea, you may do so. Okay?
Is Mr. Douglas the accuser or the witness?
He would be both.
He would be the accuser and the witness?
Yes.
So there's some type of harm, injury, or loss that Mr. Douglas has suffered?
He's acting on behalf of the county in his official capacity as a law enforcement officer.
Okay, and who's prosecuting the case?
Because of the nature of the offenses in this forum, the officer prosecutes their own cases.
So the officer is prosecuting the case on behalf of South Carolina, on behalf of the state of South Carolina?
That's correct.
And he has a law degree.
There is an exception allowed for law enforcement officers to be able to present their cases in this forum. They're not allowed to present their cases in all forums, but in this particular forum, that exception does exist. So there's no law degree that I'm aware of. I'd have to ask Officer Douglas to clarify that he does not have one. But to my knowledge, he is an officer, and therefore he is allowed to present his case.
Okay, so he has a privilege that the rest of us don't have.
You have the right to represent yourself, so without a law degree as well.
I don't know how to represent myself unless you're present.
So are you asking to be appointed an attorney?
I am not.
Okay, so are you waiving your right to have an attorney present?
I'm not waiving any rights.
Okay, but you do not wish to be represented by an attorney in this proceeding?
No, I do not wish to be represented by an attorney in this proceeding.
Okay.
So I'm just a man who's present, requiring due process of law, which would initiate the first step of due process would be to have an accuser take the stand, and I have a right to cross-examine my accuser. Okay.
Well, we are to that point, so I'll ask you to have a seat, and we'll begin our trial. And
Whoa! What about the trial?
You've asked that for a right to hear the case and have cross-examination. So I'm going to ask the officer to come forward and present the case. Okay? So at this time, sir, I'm going to ask you to sit down. Okay? You will have plenty of time to talk, but right now I know nothing about this case. I know nothing about the facts, and you've asked that the facts be read into the record. So
okay, and I just wish to be clear, I have not pled
Oh, I'm entering a plea on your behalf.
I'm not consenting to a bench trial. All I'm doing is wishing to establish the accuser and to know the facts so that I can plea on my own behalf.
Okay, well, let me ask you this. Do you want a jury trial?
I wish to move according to due process of law.
Okay, so you do not want a jury trial?
I'm not saying that I do not want a jury trial.
Okay. All right. But you're saying you want to move forward under due process?
Under due process.
Okay, so if you will have a seat, officer.
So under due process of law, not due process of statutes.
Okay. I'm not sure the distinction that you're making there, but under due process, I'm going to ask you to sit down and let me hear from Officer Douglas. Officer Douglas, would you come forward and have a seat at the opposing table? Before you sit down, though, I am going to ask you to raise your right hand. Do you swear or affirm the testimony you're going to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay. Officer, you may have a seat if you like. You may stand if you like.
Okay, so I started the recording now. Thoughts on that?
Okay, so let's get some clarity here. This is the North Greenville, South Carolina Summary Court. The magistrate judge is Kenneth Sutherland. This was Wednesday, February 16th, 2022. And there was an officer there who is a certified Class 1 deputy. So one of the things that I really wish to point out here is I think John did an excellent job of doing his best to, and speaking with the judge, to say that, ask, is this due process? And of course, the judge kept saying, this is due process. And a few minutes into it, John asks repeatedly throughout this, let's call it a trial, because that's what the judge called it, a trial. He went right into trial. And John kept saying, I want due process. Is this due process of law? I do not wish to have due process of statutes. So one of the most shocking things is when John asks, who's my accuser? And the judge said, it's the officer. Well, who's the witness? And the judge said, it's the officer. And then did anybody pick up when John asked, who is the prosecutor? And the judge says, it's the officer.
Yeah, and I noticed that he asked the officer to come forth to swear in, and he even stumbles at one point and corrects himself and reiterates the officer, which means he's in an official capacity. Therefore, he cannot be the accuser. He can be the witness. He could be. That's about it. As the witness. He cannot be the accuser unless it was in a private capacity where John injured him. Then he would have to swear in as so-and-so Douglas, and not as officer.
Well, and the other thing that John kept saying is, I wish to have the facts placed upon the record so I know and I understand how I plea. And the judge immediately said, I'm going to enter a plea for you of not guilty, and then you can change it later. And we're going straight into trial. And that's when John says, whoa, wait a minute. All I'm asking is I have the right to speak to my accuser so I know what he's accusing me of before I can put in a plea. And the judge kept reiterating, I put the plea in for you. We're moving along with trial.
Right. So it was apparent that it was under color of law instead of due process of law, even when asking for jury trial versus trial by jury. And the judge also stated that the officer could proceed in that manner as prosecutor to his knowledge as well. So the judge was toying around.
The judge also stated there is an exception allowed for law enforcement officers to present their case in this forum. What forum? That's just prior to John asking, does he have a law degree? And so the judge kept moving along in the trial. And John kept saying, you know, all I'm trying to do is find out who my accuser is and what are they accusing me of before I even put in a plea. And the judge kept moving along in the trial. John reiterated again, so due process of law, but not due process of statutes. And the judge says, I'm not sure of the distinction you're making. But again, under due process, I'm going to ask you to sit. So there were a few times where the judge kept telling John to sit, and the judge kept moving, or the magistrate kept moving along in this trial.
Right. And there's a point that stood out to me as I've listened to it a few times where he says, I wish to move by due process of law and hear from my accuser before I can plea.
Exactly.
And the magistrate says, we're at that point, so please have a seat and we'll hear from Officer Douglas.
Exactly.
So he clearly, even though John requires due process of law, the magistrate clearly leads him to believe that is what is going to take place before a separate event of a trial will be underway.
Okay, and I haven't caused you any harm, injury, and or loss.
You're asking if you have personally harmed me?
Yes, if I have personally caused you any harm, injury, and or loss.
No, sir, not personally.
Okay, do you have any complaints? Like, did anybody make a complaint that I had caused them any harm, injury, and or loss?
No one has complained directly to me about you. Sir, we are here today because I'm a representative of the state of South Carolina and the county of Greenville, and I represent the citizens of Greenville County in enforcing laws of this county of which you have breached and broken.
Okay, so you say laws, you don't mean statutes?
I'm unclear as to what difference you are making between the two.
Well, gravity is a law. Gravity is a law of nature. The legislature of South Carolina cannot tomorrow say every Thursday gravity will be reversed, and then magically on Thursday we all start floating around. Statutes are things that the legislature of South Carolina creates. They create things called statutes, which are created codification of social norms that they put in place. They create policies out of for you to enforce as a police officer, correct?
I'm sworn and certified to enforce the laws of this state and the ordinances of this county.
Okay. So you don't know the difference between a statute and law?
Sir, I understand enough about the law to be certified as a Class 1 deputy in this state.
Okay, the question was, do you know the difference between statutes and law?
And I made a statement pertaining to that, sir.
Okay, and you testified that I haven't caused you any harm, injury, and or loss. You also testified that no one complained about me causing them any harm, injury, and or loss. So now I'm going to ask, is there a verified bill of some type of damages that I've caused the state? Like, did I hit a guardrail and cause the state some sort of damage that they had to replace?
Sir, there's no bill of damage, and you are not here being charged with any type of malicious damage to the state or anyone else as a resident of this state. There's no question as to any damage. The question is to the unlawful status of your licensing of your vehicle and the driver's license that you're required to have to drive status of your license was suspended.
Which makes it an illegal status.
It makes it unlawful for you to operate a vehicle on a public roadway.
So the state can license you to break the law.
The state can license you to drive a vehicle.
That's not the question. The question is the state can license you to break the law.
I'm not aware that that's true, sir.
Okay, because, if they license you to drive a vehicle and then they take away that license, that means that it's illegal to drive the vehicle without the license. But if the state cannot issue a license for somebody to break the law, then it wouldn't mean that it's unlawful. Does that make sense?
That makes absolutely no sense to me, sir.
That makes absolutely no sense. Okay, so the facts are, I didn't cause you any harm, injury, and or loss. There was no complaint of me causing anybody any harm, injury, and or loss. There's no verified bill that I hurt, harmed, or injured the state in any type of financial way. And the last thing I would actually like to talk to you about with your time.
Okay, that was the end of the second clip. Any thoughts on that?
So once again, the officer is saying that John did not cause any harm, injury, and or loss to him, to the state, to anything. And but what he is doing is charging a charge. He's charging John. So the officer is an alleger, an account of charges. It is not an accuser. So that goes to prove that this is all financial. It's all about money. This is not in law. He's not bringing an accusation. He's bringing a charge of money. And we'll see later on that the judge actually gave a fine of $879 and 30 days in jail.
Right. And the officer couldn't even articulate the nature of the wrong. And the officer testified to not knowing the law, from what I could depict there too. JC established that there was no articulatable suspicion or intent. And the judge just essentially manipulated his words and his intent of how he was proceeding throughout the course of that proceeding as well.
The officer did not know the difference between a statute and a law. So if he or the judge cannot explain or articulate what the nature of the wrong and the cause of the accusation is, then what was he doing there? Why not throw it out? And it's so incredible to believe when here John gets an $879 fine and 30 days in jail, when those that have seen the previous videos that John did, that Valerie Owenby, who was molested by a next door neighbor from the age of 5 to 12, and she went to a magistrate to swear a warrant of arrest for James Sapp and Greg Newman, she could not get any justice. She could not get them in jail. She could not swear out a warrant. She could not get them arrested. So how absurd is this that John gets 30 days when they could not even prove any kind of the nature of any wrong that he did?
And Valerie Owenby had a judgment already awarded in the court with evidence on the record of the court already. So she didn't require any witnesses or evidence to be brought forth. Yet the system is so broken, it can allow the simple, non-verified word of a person's acting in the capacity of officer to bring forth a charge. And that's a good point you brought up. A charge requires a bill of goods or damages or services. And if there's no damages, that means there cannot be a bill. He cannot be in debt to something, and debt means guilt.
You said that when you were giving me the ticket, you explained the charge, the nature of the charge.
That's correct. When I read the charge to you, that is an explanation of the charge.
Okay, so when you explain the nature of the wrong and the cause of the accusation to the court here today, and the nature of the wrong, not the actual statute that the state puts in place, the nature of the wrong and the charge of the accusation that I'm being accused of.
I'm sorry, is there a question that you're asking me, sir?
Yes, I'm asking you to explain. You said that you explained the nature of the charge. And that's wonderful. You should do that. That's a great thing for people to be informed of. What I'm asking is, in law, somebody being charged by the state has to be informed of the nature of the wrong, which means the nature of what they did wrong, not just you broke or violated some sort of state statute, but what you actually did wrong in the moral sense of causing harm, injury, and or loss to somebody else, or causing the state property to be damaged in some sort of way. That would be wrong. So what is the nature of the wrong and the cause of the accusation, not just the nature of the charge?
Well, sir, to answer your question the best way that I can, I'll revisit one other fact of our interaction on January the 11th. I do wear a body-worn camera, and I am required by the Greenville County Sheriff's Office to run that camera when I am in contact with the public. I was indeed doing that the day that I encountered you, and so all of our interaction would have been captured on that body-worn camera. I can tell you, for your rights, I have to inform you of the nature of the charge for which you are being charged. I did meet that standard on scene with you there that day.
So the fact is, law is not being upheld. The fact that there is no nature of the wrong or cause of the accusation upon the record of the court, and the fact that no one could explain the nature of the wrong and the cause of accusation. So he doesn't have jurisdiction. So when we look at jurisdiction, it cannot be assumed and it cannot be presumed. It has to be proven upon the record, and upon the record, it was quite proven that he didn't have it. Because the accuser, the person he says is the accuser, I mean, that's like the first time in my entire life that I ever heard a judicial officer call a cop an accuser. So now we are reaching out to every one of you because we have been inundated with text and phone calls and messages that we are encouraging each one of you to make a phone call and record it, and to send out letters. And it must be a letter, I believe, with a signature.
Yes, they're all going to require a signature, and I will post the elements required for these complaints, as well as exactly how and where you need to send them, points of contact with names, if you wish to be of help and make the calls. And please record all, because every man, every woman keeps their own record. As we know, the courts do not honor that. So we're asking for everybody's help in this matter, and we will provide everything that you're going to need, and it should only take a few moments of your time.
And it's only our efforts that's gonna get him out before that 30-day period's up.
Yep, there is strength in numbers. So the question is to Henry McMaster, governor of South Carolina. Why are you appointing magistrates that do not know and do not understand law? And if he is appointing magistrates that do know the law, why are they not following it? That's the main question.
Yeah, a trespass against one of us is a trespass against all of us.
Absolutely.